Good afternoon. How are you?
I'm okay, Mr. Archer.
Oh no, you don't sound have no energy.
This is just me. I always sound like this.
Oh, okay.
Yes,
Let's wait on the others.
no problem.
Okay. Give them a couple minutes. Good afternoon.
Good afternoon.
Let me see. Shanique, you didn't send me any homework.
Yes, ma'am, I sent it. I sent it last night.
Last night. Hold on. No. Under what name? And your name?
I am not sure. My email is shanique98@gmail.com.
I have
Let me
homework
check
from
on.
Lorenza, Russell, Nadia, Vincent.
Russell. That's me. Russell is me.
Oh, that's you?
Yes,
Oh,
I think my first name on my email is TVLZ or something like that.
yeah, and I don't know who that was.
Sorry, that's me. Sorry about that. I need to
Okay.
change your name. Yes, ma'am.
Yeah. Yes, you need to change that. Okay. All right. Should we wait a couple more minutes or you're ready to start?
I guess you could give them 2 more minutes, I guess.
Yeah, we'll give a couple more minutes. Not a problem. You can pull out your homework in the meantime.
Mr. Archer, do you work for the bank?
If I work for the bank or for a bank,
For a bank, yeah.
Used to. Yes. And your question? Or that's just a general question?
Just a general question.
Yes, I worked at Central Bank for 32 years. Then I worked at Scotia. And then I worked at an offshore bank, and now I work at a law firm.
It's a pretty decorated resume.
Hmm?
They said that's a pretty decorated resume.
No, a very long one. I don't know if it's decorative. And where do you work?
I work for Scotiabank.
Ah, see, which one?
Um,
The bank itself? The
East
retail?
Street and Soldier Road at the moment, yes, sir.
Oh, down there. Oh, okay.
And the majority of us work for Scotiabank in this class.
Oh, okay. Well, I was at Scotia too, downtown.
Okay.
In compliance. Taylor, how long you been there?
July this year made me a year, so we're fresh in the
Oh,
bank. Yeah.
okay.
So far, so good, though. I enjoy it.
At Scotia almost 10 years. I would have worked at Scotia Bank, the retail. I also work for Scotia Caribbean Treasury, Scotia Turks and Caicos, Scotia Cayman, and Scotia BVI. Mm-hmm. Yep, I did.
And did you enjoy the law firm more, or did you fancy banking more?
No, if I like, those only sound muffled. Say it again.
Do you prefer working in the law firm, or did you prefer banking?
But working in the law firm, I'm still doing the same thing, which is compliance.
Ah, okay.
Yeah. So in the law firm, I do compliance for a group of entities. So I do it for the law firm, we have a fiduciary firm, we have a trust company, we have a corporate service company, and then we have a management company.
Oh, okay.
Yeah. So it's 5 different entities. And then I the chief compliance officer. So when I was at Scotia, I was the regulatory manager. But in this role here, I cover compliance and I cover governance and I cover risk for all of those entities.
Okay.
Mm-hmm. Yeah. So in Scotia, you all have a lot more opportunities now, I would assume.
In regards to promotions and stuff, that's what you mean.
Yes.
I'd say yes. It's I wouldn't say it's easy to move up, but it's easy to get out of retail if you know were interested in other departments such as compliance, money laundering, credit risk, and stuff like that.
Yeah.
They provide the opportunity, and it's a lot of training as well. So even if you're not able to get the position, you are able to cross train, so you gain the knowledge for future job openings and stuff like that.
Yes, yes. And I remember when I was there, I think one lady, she went to Hong Kong. Yeah, different places around the world. Some people went to Canada. So there are opportunities.
Right.
Yeah, they are. All right, let's start. And whose paper do I have first? Is Ellen on? Let me see. No, Ellen isn't on. So I don't have to do Ellen's paper. Okay, Taylor, let's start with yours then. We're talking about Eve.
Yeah.
And okay, so I'm reading your facts. So you're telling me she entered into contract. She is in breach. What your third bullet point, what do you mean when you say Eve should not have been able to enter into any contractual agreements legally?
Because like as it states, you know, minors can't, and so, because there are restrictions when it comes to minors, and I think it was impaired person. Only if it's a necessity, then the minor could enter into a contract. But to me, I view holiday as a luxury and not really a necessity. So
That's how that the right stop right there. That's having a one mind track.
one track mind, yeah.
One try, yeah. Yeah, because if someone, if I am booking a trip to go to Freeport or wherever, it doesn't necessarily mean that I'm going on a holiday.
Okay.
For enjoyment.
Okay.
Because some people will say I'm going on a holiday, but they may be going for a specific purpose. So
Right.
in your third bullet point, where you have your second sentence should have been your first,
Okay.
right? And then you should have said, if this is a necessity,
Mm-hmm.
then explain, right? And
okay.
if this is not a necessity,
Mm-hmm.
then the contract, of course, would be void.
Right. Okay.
Because it's right. Yeah. So you have to speak about the necessity first.
Okay.
And then you say yes or no. Now, if I'd given you more information, then you could have determined whether or not it was necessary or not.
Right.
Okay, I get your last bullet point.
Mm-hmm.
Now another thing you need to consider is this.
Mm-hmm.
Can the company get back the difference that she owes?
Right, and that's another thing with reading the scenario.
Mm-hmm.
Because I tried to do the calculations, but it wasn't really disclosed the cost for the trip. So
Yeah.
right, so how what would the assumption have been on how much she was to repay? Because she initially paid the $80, and then she paid $20 for, well, she should have paid $20 for a period of 6 months, right?
Uh-huh. Uh-huh.
So she paid $120 in all. So that means she would have paid the $80, and then I guess 2 months payment, right?
Mm-hmm. Right.
Okay.
And so then remember, I told you our last class, you have to make an assumption.
Okay.
If the information isn't given, you'd make an assumption.
So what would be if she was entitled, or if she had to pay the travel agency the remainder? If she didn't, what would be her punishment?
Well, none.
Right.
If it is for necessary, then she's going to have to pay.
Right. Okay.
Right. But if it wasn't necessary, then she's not going to pay the difference.
So it's a two outcome scenario then.
Yes.
Okay then.
Mm-hmm. All right. Let me check someone else's now. That was yours. Okay. Shanique. Well, what answer is this? Let me see. No, I think you have Shanique.
Yes, ma'am.
Okay. What is this you
Yes,
sent? Where's the first question? Hold on.
I sent them separate. The first one is.
I see it. The first one you have is number 2, and then number 2 you have is number 1. All right.
Yeah, sorry about that. Yes, ma'am.
That's all right. That's all right. Okay, so you start right out by saying the travel agency should not have entered into agreement. Why is that not correct?
What is a me? Hold on, let me bring up my answer.
Okay.
But I stated my facts first, so I stated what was the issues, and then I stated the questions.
Yeah. Okay. So we're answering your question number 1. Should the travel agency have entered the contract with Eve as she is a minor? And you said your answer is the travel agency should not have entered into it because she's a minor and doesn't have legal capacity.
Yeah.
Unless it is for necessity.
Because I was looking at it as it wasn't a necessity.
Okay, no, that's all right. But don't start off by saying she should not have.
Mm-hmm.
You're giving me a no, and then you're giving me a maybe. So you could start off by saying you could have started by saying Eve is a minor, and as such, the travel agency may enter into a contract with her for necessities.
Yes, ma'am.
Yeah. That's a decision that they have to make. Because if they enter into this contract and it is for necessities, then of course they have a binding contract. But if they enter into the contract under the assumption that it is not for necessities, then of course they can expect to be paid.
Yeah. Huh.
Right. And then when you come to the other paragraph, when you say whether she should pay or not pay, it depends on whether or not it was for necessities or not.
Yes, sir.
Okay. So you just have to remember when you write your exam questions, you have to be clear. You know what the rule is.
Yes, sir.
And it goes either it's for necessities or the contract is void. Or based on her age, she can ratify it when she gets 18, but that'll be a long time away. She only have a couple months of this bill.
Yes, sir.
Yeah. Okay, let me see who else is on. Nadia isn't on, so I don't have to do Nadia. And that's it. Let me see, hold on. Vincent isn't on, so I don't have to do him either. So let's go back. Let's start with Taylor. Okay, Taylor, tell me, explain your answer for the second one. Ms. Swain complained that the bank has paid a check on which she had countermanded payment. However, she does realize that while she quoted the correct payee and amount details, she did not state the correct check number.
Okay, so my response to that is first the facts.
Mhm.
So the facts are Ms. Swan compliance that the bank has paid a check which she requested to be countermanded. From this interaction, it can be said that Ms. Swain and the bank are in a debtor-credit relationship fully versus ill. And then the request that the check countermanded was overlooked by the bank rep, resulting in the payment of the check. And then I referenced Curtis versus London City and Midland Bank. And then I went on to state the countermand process, which is that the customer may request countermand check via, according to Scotia, via visit to the branch and give verbal authorization. And then of course they would have to sign the maintenance form once the process is completed. A written and signed letter of instruction can be forwarded via email. So this would be the second way they can request the countermand, where a supervisory or managing officer would complete a callback to verify the request, resulting in the countermand being placed on the check. And then the third point under that would be that all information regarding the stop payment provided by the customer for the check, in brackets, the date, the payee, the amount, the check number, the signature, etc., must be accurate. And then I referenced London Stock Bank versus Macmillan and Arthur. And then my overall outcome was that Ms. Swain, because Ms. Swain is aware that she did not provide the correct check number, legally, we, the bank, are not in violation of any terms and conditions of the bank and customer contract between us and Ms. Swain. That would be Joe Hinton versus Swiss Bank Corp. Therefore, the bank won't be liable to any losses or damages sustained by Mr. Swain, as he acted solely on the instructions that she provided. We can offer an apology to Ms. Swain, as we could have performed due diligence to analyze her account in detail, where we possibly could have discovered that, the stock for the same payee on the check was there, but then I closed it out. As per my banking institution, we can only act on the customer's instructions. Therefore, we won't be held accountable for the check payment.
Okay, very good. Very good. Y'all just seem to have a little difficulty when it comes to pure contract questions.
Yeah, I don't know. I think it's because we spent so much time on the chapter 4, these laws and stuff. So we grasped that concept a bit more. The contract, we only had the one assignment. So, and then because the scenarios are so vague, the fact
but I see, I don't want to give you for contract too much detail, because the class is not a pure contract law class. Right, you see what I mean? But then I'll have to give you all contract cases. like how you're using the banking cases. I'd have to give you contract cases, and I don't want to go that deep. So I'm
Right.
just trying to keep it as simple as possible. But I
Okay.
still want to, like, the way you rationalize your answer, I still expect you to try and do that in a pure contract way.
Right.
Yeah. Now, I know you do it better in banking because that's what you do every day. But
Yes,
remember that banking is based on contract law. So it's the same premise when you're thinking, the same way you logically go through that, as the same way you logically go through a contract question.
Okay.
Okay. So the last one you did last time was very good, and this one is very good.
Thank you.
So now let me go to Russell. Let me see what she tell me. Shanique, why is this a quarter of a page?
Honestly, when I do them as actual, like I completely go on blank. Honestly, that's question 2, right?
Yes. Well, you need to
Yeah.
resubmit this thing. You need to resubmit
Okay.
it because the same way you see how Taylor was able to break that down, that's how he can answer a question in exam where it's worth 10, 15, or 20 points, and he could get almost perfect mark for that.
Okay.
Because he went through it step by step. And remember, I told you all in the class before this one and the one before that, when I think it was Taylor and 2 other students asked if they could use their bank's policy. And I said, yes, you can. You can apply it. And where relevant, you could use the law. But you need to learn how to practice, how to answer these questions. Because you're going to go in the exam and you're going to write these same 3 or 4 sentences. And then when you get your grade, then you can scream. Let's see something. Okay. Nadia.
Yes, ma'am.
Okay, so tell me what you wrote. I'm looking at it.
We talking about
Number
the
2.
first.
Yes.
Okay. So what I wrote about it is, I guess I started with talking about how it is the bank's duty to follow through with the instructions given by the customer. So Mistress Swain, she gave the bank instructions to stop payment on a check. So if the bank had not followed through on the fact that she asked them to stop the payment on the check, then they would be liable. And then I went on just to talk about what what is needed to stop a payment on the check, talking about the check number, the information on the check number, the recipient's name, the date of the check, the amount, and so forth. And because she gave them the wrong check number, I did point out where you can have the same name. You could write a check for the same person, the same date, the same name, but of course every check number is going to be different. So because the check number did not match the one that she provided the bank with, that kind of was a mistake on her part. And I referenced the case with Westminster and Hilton, I think, where the bank cannot be held liable because of the customer's mistake. And yeah, because of the customer's mistake, the bank cannot be held liable.
So Westminster Bank versus Hilton says that the stop order must be clear and unambiguous.
Right. Yes.
And the check number is one detail which is unique.
Correct. Okay.
And I see you put it here because you have the countermand must be clear and accurate, as the bank is not liable for the customer's mistake.
Okay.
Okay. Do you work in a bank?
I do.
Okay. So similar to what Taylor did, remember what I said in answering this in the middle of this, before you get to the paragraph to stop payment on the check, you must provide the bank with the correct check number. Remember how Taylor said he tied in the bank's policy.
Okay, I don't think
Procedure.
I heard. I don't think I heard his response completely. I came in on the latter end of what he was saying.
Yeah.
Right.
But we spoke about what's required by the bank for a stop payment.
Mm-hmm.
Then he wrapped it up by bringing in the case.
Okay.
Right. So what I want you to put in your mind is that if you have an issue that comes before you, you will begin to think that, yes, this person had a countermand, but what is the bank's policy? I want you to tie in the policy with the issues as they come in. And then you can add in the common law or the statute as is applicable.
Okay.
Yeah.
Okay.
So that's not bad, but you just need to tie in your bank's procedure so you begin to see how it actually works and how
Okay.
you should be thinking when you have an issue. So anytime someone come there and they have a complaint or they have a problem, your mind should go, okay, what really is the problem here in banking? Not emotional. What is the issue?
So
And then go ahead. Go ahead.
I kind of have some, I guess, some research to do as far as that, because I do work in the bank, but I haven't worked in like customer service or front office as far as dealing with things like these.
Mm-hmm.
So I guess
Gotta
that's why
read.
my mind didn't really go that
Yeah.
much into detail about it.
Okay, so now you're in this class, you know that you have to reach out to someone when you have a homework question. You need to reach
Right.
out, and that's how you learn more.
Right.
Yeah.
Okay.
Okay. Because it doesn't make no sense you doing this class and then you're not looking at your company's procedure or policies to see how it ties in. How does it relate?
Okay.
Yeah. You don't want to come out disjointed. Okay, so I learned all of those cases, like how are they relevant? I mean, how do I apply them to what I do every day?
Okay.
So while you're in class, you need to search for it so you really understand what this banking law is all about. And we're gonna do a case. We're gonna read a case tonight as an example, and then I'll give you all another case to do. When is the exam? Next week?
Yes.
Yes,
Okay. Oh, wonderful! I need to write it this weekend. So
do
yeah.
Do we really need homework if the exam's this next week?
No, I'm not giving you homework. The homework
Okay.
I'll give you be 2 cases to read, not for Wednesday coming, but a Wednesday after.
Okay.
And you have the cases already.
Okay.
Yeah. So don't stress.
Okay.
Okay, so that's the only ones that I have. That's the only one. Okay, so now let's go to our chapter for today. You want to, so let me see, how many more classes we have? Hold on 1 second. Whether I should do the classes or do a small review. What you think?
I think the review would be best.
A review.
Okay, hold
Just
on. Let's check my calendar first.
Future chapter.
I have to pull out my diary. Now I know the request at couple weeks ago was 50-50. Y'all still for that? 50 multiple choice, not 50, half the exam multiple choice, and the other half scenario. You still for that?
Yes, ma'am.
I mean, to be honest, what would be an example of a multiple choice question? Like, which one of the chapters would be an example of a multiple choice question?
I'm thinking. It could be chapter, hold on, let me move my thing on. Because I was going to do types of accounts tonight. Oh. Hold on. The chapter on the one just before contracts. What is that? The one talks about how a bill is enacted, that chapter. That's number 2.
Yeah, number 2.
Yeah,
Legislation and stuff like that.
that can be a multiple choice question. Chapter 3, contract. That could be scenario and multiple choice. And then sometimes I would use some of the cases as multiple choice to see if you've actually read them.
Okay.
Yeah, so there's different ways. Some students like multiple choice and some people don't. But I could hear the chorus is saying yes.
I guess the half and half would be best.
Okay, so half and half it will be.
Because you already stated that your multiple choices are much harder than the structured questions. So
I prefer the structured questions because then I begin to see how you think. And then I could tell from then whether or not you really understand. To me, multiple choice is just guessing.
I understand.
Yeah, but I mean, if you all want them, I will give it to you. That's not a problem. So we're on 25th. Hold on, let me turn to November. So we have the last day of class as the 29th, right? Of November. I mean, the 22nd.
Not sure.
8, 9, 10. This class is 12 weeks, right? I'm gonna check with the office. Okay, so we have the midterm on the 1st. And then we will do types of accounts on the 8th. Oh, and I wanted to say too, the chapter on checks, if you all will agree, instead of us turn to the chapter on checks. The chapter on checks is very long. It goes through all the details on operating a checking account. And I know that has made the announcement that he wants to disband the checks. And because of the electronic age that we're in, everybody is moving away from this check. I wanted to propose that I give you a paper to write based upon this change or the advancement of technology in banking and the discontinuance of checks. How does that sound? And make it a 20-point question as part of your final exam. But you take it home and you prepare an answer.
Yes, ma'am.
Because since since the governor is moving away from checks, I say this for you all to sit down and go through all of this and learn all of these rules. To me, it's kind of like half and half. Y'all let me know what you think. We can still talk about negotiable instruments and what they are. And you all have, based on your day-to-day work, you know about post-dated checks. Now, let me ask you another question. Have you all ever read the bills of exchange?
No, ma'am.
Okay, because the rules for checks is in that piece of legislation. So what do you think? Because we'll talk about checks based on the Bills of Exchange Act, and we'll also look at forgeries. But I'm saying we're in that age now where we're moving away from checks. What do you all think?
Sounds good to me. Majority rules.
Okay, majority, because then I would formulate a question. Like I said, that'll be 20 points. It'll be part of your final exam, and I'll write you all a question about the impact of the discontinuance of checks and something else. That sounds good?
Yes, it does.
Okay, all right.
Yeah.
So I'll just briefly discuss negotiable instruments. On your chapter 8, make a note to either print or have on your computer for that class, the Bills of Exchange Act. You know where to find the acts, right? Yes?
No, ma'am.
Go to the laws of the Bahamas and click on alphabetical. It'll come up and then hit B. Go down, you'll see Bills of Exchange. That'll be for chapter 8. All right, so let's go back to chapter 1. Because I know everybody is working and these days is run up rather quickly. So
Sorry, Miss Archer, where did you say to look for the acts again?
laws of the Bahamas.
And you said to click B, and then it would be bills of exchange, you said?
Bills, B-I-L-L-S of exchange. You see it?
I see two. I see bills of exchange act and then bills of exchange Bahamas act. Which one would it be?
Bills
It's
of
two different.
exchange,
It's two
Bahamas.
different. Okay,
Hold on, I go in there right now. Let me see what
Okay.
what you're reading.
but it's actually three because they have an amended one in 2012. There's
Okay,
one 1859, 1882, and then 2012.
very old.
Hmm?
I say they are very old.
Right.
Okay, so it's laws.bahamas.gov.bs.
Right.
Okay, so you go there, go to legislation, go to acts,
Mm-hmm.
alphabetical order. Go to B for bills. And B-I-L-L. Okay, so you have the Bill of Exchange, Bahamas Act, the Bill of Exchange Act, and then the amendment.
Right.
So the Bill of Exchange, Bahamas Act
Mm-hmm.
is only talking about the rate of interest
Mm-hmm.
and damages to bills. We don't use that.
Okay.
Not that one. You go into the next one. That says the Bills of Exchange Act, and then you'll also print the amendment.
Sure.
So if you hit that one, you see what it says? It speaks about the actual bills of exchange.
Right.
And then it'll talk about checks. In part 3, checks on a banker. And they'll talk about promissory notes.
So you say this and then the amendment. Okay.
So we'll talk about negotiable instruments. Because remember now, in retail banking, you have checks. When you go into trade and industry, like let's say a big company that does large transaction, they're shipping corn, they're shipping rice, they're shipping fish. They don't work on checks. Those big contracts, they work on promissory notes because those are negotiable. So it's a different instrument that they use for those type of business rather than checks. So we'll talk about those, and then you're going to do the paper with the question that I'll pose on the discontinuance of checks in the Bahamas. All right, so now let's start. Who could tell me why was it so important to begin this chapter or this whole course on the statutory framework of the Bahamas? Anybody? No volunteers? Capron?
Can you repeat it?
I said, why was it important to begin the first chapter with the legal framework?
Because you had to understand, we had to understand pretty much the basics of the law before we go directly into banking law.
Yes. And go ahead.
And I guess it also gives us, I guess, how the law ties, well, how banking ties in with the law, and then the necessary bodies needed to properly run a bank in accordance
Yes.
with the government and legislation.
So the legislation, I remember, think back before you even open this book. Banking law is based on contract law. And you have to put in your mind that the Bahamas itself is part of a commonwealth of nations. So when we became an independent country, we took on that common law because we were a former colony. And so that means that we follow common law cases. So whenever you start any type of business, there's always a legal framework. And that legal framework has changed over the years. So for banking, the first two pieces of legislation are the framework. One, the Central Bank of the Bahamas Act that governs our macro and micro economics in the country. And it also governs the domestic banks in terms of stability for the economy. And then we had the Banks and Trust Companies Regulations Act that supervises the banks, the trust companies, private trust companies, money service businesses, and credit unions. And in particular, that piece of legislation, along with the central bank, was recently enacted. The previous ones from 2000 were repealed. And so our Banks and Trust Companies Regulations Act is modern. And it takes into account all of the nuances that are happening now in banking. So in particular, when we looked at the Banks and Trust Companies Regulations Act, what sections did we say was important? Anyone can remember? Nobody could remember? I know you remember section 77. Yes?
So confidentiality of one, right?
Yes, that's one. And then we also spoke about the definition of what? Bank, deposits, all those things you should know. What are the powers of the inspector? what information can be divulged to a parent company.
Mhm.
And then we know that with a bank, one of the services it offers is deposits. And so we have the Deposit Insurance Act, and that only covers domestic banks. And you can go to the Deposit Insurance website. Have you been there yet? Yes, no?
No, ma'am.
Well, you need to go to the Deposit Insurance website. Because you have to be able to know, well, you should know the coverages based on the amount that you deposit with the bank. Then the chapter that we're going to do after different types of accounts, which deals with money laundering. You should know the legislation that governs money laundering in the Bahamas, the Proceeds of Crime Act, the Financial Transaction Reporting Act, and regulations.
Miss Archer, these for our midterm or these for our midterm or for the final exam?
Midterm.
Okay.
Don't forget now, for the final exam, you will have a money laundering scenario question. But for the midterm, we only just did looking at the legislation. So it'll be a question related to something that's already in your book. So I may ask you who is a pair and give you some choices in a multiple choice. I could give you a list of legislation, ask you which ones govern money laundering in the Bahamas. So based on your notes, you should be able to see from Unit 1 the questions I can ask you. But just remember that when we did the Banks and Trust Companies Regulations Act, we went through the act itself and we looked at certain sections that were important. In addition, we also looked at the Data Protection Act. And then, of course, there were the related computer legislation. So if we move to chapter 2 speaks about our legal system. And it explains what law is and why we need it and where our law came from. It then explains about the different types of law: public law, private law, criminal law, civil law, and you should know the difference between the laws. And then the kind of actions that could be brought under each one. So you know if it's civil law, you could bring an action for breach of contract, or you could sue someone for personal injury, or it could be a tort, a nuisance against someone. Criminal law, you know, murder, armed robbery. breaking and entry. Then you spoke about why we have legislation, why it's important. And I gave you 3 bullet points on that: to regulate and control society, to raise taxes, and of course, to create, repeal, and revise and reform the law. So as a former colony, we have sources of Bahamian law. So our law came from English common law. Then we became an independent country, so we got a constitution. We have our own Bahamian case law. We have our own legislation. Primary legislation are the acts. Subsidiary legislation are the regulations. And of course, another source of law is custom, looking at the way people do things. And once you do it a certain way over time, it becomes a custom, even though it's not in law. We also, as a source of law, have international treaties that we have signed onto.
I found this on the web.
That's my watch talking. And of course, another source of Bahamian law is equity. This means when judges make a decision, they have to be fair and just. So what is judicial precedent? Anyone can tell me? No? So judicial precedence is looking at, put in your mind the structure of the court system. At the very bottom, you have the magistrate courts and the tribunals. Above that, you have the Supreme Court, then you have the Court of Appeal, and then you have the Privy Council, the highest court of the land. Cases that are being tried above each one of those are binding on the courts below it. If there is a decision from another Commonwealth jurisdiction, they can be used here in the Bahamian courts, but they will be persuasive. Now, in some cases, the decisions of the Privy Council that are coming from other Commonwealth jurisdiction, some of those are binding on this jurisdiction, especially when the law in that jurisdiction is very similar to ours. So when you look at a piece of legislation and you want to refer to the legislation from another Commonwealth jurisdiction, such as from Canada or from Australia, and when you look at presenting that case to strengthen your position, you have to look at the status of the court, which makes the decision, and its date. And then you also have to look at the reputation of the judge, because that influences the court. So then when we move further into chapter 2, we gave you information on the magistrate court, the Supreme Court, the Family Island administrators. And then we talk about when you read cases, there are certain parts of a case that speaks to the reason why the judge came to his decision. And that is called the ratio decidendi. And the ratio decidendi is where the judge states the relevant facts. The same way I give you a scenario and you state, these are the facts, the judge does the same thing in a case. And then he explains how he is about to get to his conclusion. And then he gives you his decision. Now, sometimes when the judge is in the middle of making his decision, he may start to speak of another case that may not be directly relevant, or he could speak about things that he see happening in another jurisdiction that's very similar to the case that's before him, and that's called obiter dicta, which means by the way. Another principle that can be used is stare decisis, which means that the decision before the lower court, the higher court is now saying, let the decision stand. They're not changing it. Now, sometimes when there is a decision from the higher court and the lower court is now referring to that case, what he can do is distinguish it. Because remember, the decision that's on similar facts, a lower court has to follow what was said in the higher court. So in order not to follow that case from a higher court, he has to be able to distinguish it. And distinguish it means that they then have to say why the facts are different in the two cases, so as not to come to the same conclusion. Any questions so far?
No.
And then we spoke about rules of statutory interpretation. And this is how the judge, when he's reading the legislation, these are the rules that he will use. So because you see the words written there in English and you see commas and colon, in some instances, they are not interpreted just as you see it in writing. There are rules that goes with those legislation. And one is the literal rule. And with the literal rule, what the judge does is he tries to in his mind, to figure out what was the intention of Parliament when they enacted that piece of legislation. And then he tried to give meaning to that piece of legislation based upon what's written. So if the interpretation doesn't make sense or doesn't give the result when you read it as to what was intended by Parliament, then he will use the golden rule. Now, there are some statutes that were actually written to defect a mischief in the law. This means someone is doing something that they should not be doing. Like we have the Vagrants Act, or someone who is urinating on the side of the building in public. That's a mischief act. So the act was done to remedy a defect or mischief in the law. And then the other rule of statutory interpretation is ustum generis rule, which means that when the legislation has a string of examples and you are applying that section of the legislation, the judge then looks at the item that you have before you and see if it follows in that line. So say the legislation says, and this law is applicable to cars, trucks, etc. And the matter that before the judge is a bicycle. That section of the act will not apply. Why? Because the examples given speak to a vehicle, one with an engine and two with four wheels. That's what the justum generis rule is about. General words that follow particular words. And then the last thing in that section, we looked at how a bill becomes an act. The process from an actual ministry or from a minister, member of parliament, and the steps it goes through to actually become law. Any questions?
No
No.
questions.
So y'all don't need a review.
No
We
man.
do. We
No,
need,
man.
we need the refresher.
So when you start studying, it won't be that far away.
Right.
Yeah.
All right, so chapter 3. Chapter 3 was the basis for when we started to look at banking law. And I started by saying that banking law is premised on contract law, meaning that in the bank, when a customer comes in, they sign different contracts based on banking principles. And then I told you that in order to really understand banking law, you have to understand contract law. Now, we define what is a contract. And we said that it's a legally enforceable agreement, bearing in mind it can be verbal or it can be written, but it gives an obligations to the parties to the contract. That's where that term privity of contract comes in. The contract is only enforceable by the parties to the contract. And under any contract, there are always obligations. So when someone says, do you have a valid contract? There are essential elements of a contract. You have an offer, you have an acceptance. That's called an agreement. Then you have to have consideration. That is an act done or money. Now, in order for you to say you have a valid contract, in addition to those three things, both parties or the parties must have the intention to create legal relations. That is that both parties agree they know what they're getting into. They know that one is buying, one is selling. And they must have the capacity to enter into that arrangement. So in addition to those essential elements, there are other things that should be considered when you're trying to ascertain whether or not a contract is valid. One is whether that whatever the arrangement is, was it done in the required form? And an example would be if you were to purchase land, there is a required form for that. And the required form is it must be in writing. Then, of course, you have to look at whether or not the contract itself is legal, ensuring that it's not against public policy. So it has to be a contract for something that in law, it doesn't fall outside the laws of the Bahamas or the laws of any jurisdiction. Then you have to look at what they call the genuineness of consent, which means you have to determine whether or not one person misrepresented to the other party some facts, or someone tried to influence someone to enter into a contract. And of course, for a contract to be enforceable, it has to be valid. And so it has to be valid means that the essential elements must be there, in addition to whichever one of these essential elements have to be added to that in order to make that contract complete. Another essential element of a contract is that it must have terms and conditions, depending on the type of contract or the product that is being purchased or the service. There are certain terms that have to be in that contract in order for it to be valid. And again, you're looking at either party's responsibility, you're looking at their obligations, you're looking at the duties on either side, the extent of it, the liability, insurance, waivers, all of those things, depending on the subject matter of the contract. The contract should also speak to discharge. What if I wanted to terminate the contract early? A clause should be within the contract to address that and any penalties. Then there is limitation. Sometimes a contract was only open for a certain period of time. So you're looking at the duration, or you're looking at the start date, and you're looking at any penalties that's connected to it if you don't start or finish within a certain time. And of course, when someone is unable to meet the requirements of the contract, then of course, legal action can be brought. And so you have to look at redress. What can I sue for? So then we went through what is an offer and what's the difference between an offer and an invitation to treat.
Ms. Archer,
Yes.
I have a question with this, the essential elements of a valid contract. Because I think
Yeah.
I was kind of struggling with the question with the minor.
Mhm.
So when it came to the legal capacity, right? Like we know that they say minors don't have the legal capacity to enter into the contract, right? But
Except for necessity.
okay, so I read in the case with I think that was Fleming versus the Fleming case, where it was about the gold ring or was not. So the contract would be valid if okay, a gold ring wouldn't necessarily be considered a necessity, correct?
Correct.
So if we're just looking at that generally, that means the contract would not be valid?
Yes. But remember now, necessity also looks at the person's status in life. If the
Okay.
person is from Baytown and they're buying a gold ring, that is not a necessity. If the
Okay.
person lives in Lightfoot Key or some resort, and that is their lifestyle, that is what they're used to, and let's say they say when they reach the age of 16 in their family, there's a tradition that you buy a ring to put on your pinky finger and you put the initial of your family heirloom or something on it, then to them in that group, it is a necessity.
Okay, so basically if whatever the question is about, if you could prove that it is a necessity, then that means that the contract would be valid?
Yes.
When it comes to minors?
Uh-huh.
Okay, so with the question that you asked with the homework, as far as the travel, so like
Same
if, go ahead.
It's the same thing. If
Okay.
the travel was just, if the person was traveling and it was a necessity, then they're bound to pay.
Okay. So and if it was just a vacation or was not, then even though she had already taken the trip, then the contract would still not be valid and she wouldn't have to pay?
Exactly.
Okay.
But the funds that she had already paid, she couldn't get that back because she had already taken the trip.
Okay.
Yeah. She just
Thank
wouldn't have the balance.
Okay.
Any more questions? That's a good one. But I think you'll get this minus down pat. I could give you a different type of question. What do you think? A different contract question.
You mean on the exam?
Yeah.
Yeah, we had too much of the minor.
Yeah, I could change it.
What?
I know. What happened again?
Why y'all like that?
You don't have too
serious,
much
man.
minor questions, man. They too vague.
Yeah, we don't
City,
want all
it
hard
goes on
questions,
the
you know.
exam.
You want 1 or 2 questions, you know, you can get a couple points for.
Well, for every minor question I do bad, so I don't know.
Answer.
Oh Lord.
Majority rule the massage. I go with the majority.
No, I don't have to give minor questions. I can just give you all a general contract question. I don't have to be that. I could give you all one with someone trying to sell something. How that sounds.
I don't know.
Man,
I mean, it would be the same
it's the
basic
same
stuff,
thing. Yeah,
just
same
that
thing. Yeah,
the
it's
person
the same
probably
thing.
might have to pay back because, you know, with minors, them entering contracts is, 50-50 thing.
Yeah. But I mean, I could give you all something where someone is entering into a contract. I think I could find something. I don't have to give you a minor. I could give you something else. You won't die. It ain't gonna be that hard. I can give you one on selling a car. Remember we did that one?
Yeah, that was a interesting question.
Yeah.
I think there was a lot of ways to answer.
Yeah. Mm-hmm. Yeah. I think yeah. Something like that. Or something similar. Okay, so no minors. Let me make a note. No minors. Okay, that's done. All right, so then we went through offer, acceptance, consideration. We all had that down, Park. And then the remedy. What the remedies are for breach of contract? Without looking in the book. Somebody give me one.
Damages.
Yes. What else?
Damages. Would it be compensation? Like, I guess like whatever. I guess for the cost of the damages.
Maybe, yeah. They call it quantum merit.
Okay.
As much as it's worth. And then of
Like
course,
some.
the agreed sum. So if I had to ask you, what are the remedies available to, I don't know, Sam? Like if I ask you 3 different questions, and I asked one of them, I said, what are the remedies available to Sam for a breach of contract? How would you answer that?
In accordance with the same 3 remedies we just listed.
But it's more than 3 remedies, remember? That's what I wanted to see. If I ask you, what are the remedies for breach of contract for Sam? Then you should say the remedies for a breach of a contract can either be under common law or under equity. Remember? Common law is damages, action for agreed sum, or as much as it is worth. But when you get equity, and you only get equity when damages is not adequate. And remember, I gave you injunction, rectification, specific performance, and rescission. So you have remedies under common law and you have remedies under equity.
Okay.
So don't forget that.
So something like that would be, I guess, a multiple choice question, or you would structure that?
It could be either one. Could be either. And how do you discharge a contract?
One would be mutual agreement
Yes.
by both parties.
Mm-hmm.
If I remember one of the homework questions, if I guess let's see, if the person who agreed to the contract were to like, I guess, go against what they state would be one of the terms and conditions, if they were to like, I guess, break a term and condition that they placed, then that would be a breach.
Yes, that's a breach. That's two. Two more.
If both persons in the contract, I guess, do what they said they was gonna do in the contract, they live up to both end of the contract.
Mm-hmm. That's three. One more. Students always forget this one.
We talked about this one with the lady that was getting her house fixed, right?
Mm-hmm.
The pipe burst.
Frustration, if they're angry.
Yeah. Frustration.
Okay.
Frustration is an event that is out of your control. Like say you hired a contractor and he has 4 months to build a house and then Hurricane Dorian came. That's frustration. He can't finish the contract in the time frame that was agreed to. It's out of his control.
Okay. So
Right.
in an instance like that, would the person like would he reimburse the person for any, I guess?
It depends on what's in the contract.
Okay. Because the cost of labor and stuff.
Because remember what I said at the very beginning about a contract. The contract has to have provisions within it that takes into consideration all the relevant things. So if you're building a house and you know you're building a house starting in June, that is hurricane season, you should make sure that provision is in there. You see what I'm saying? Because that's to protect you as the contractor. So you should make sure there is a clause in there. We call it force de majeure, that if anything was to happen, any natural disaster, what happens to the contract? And that needs to be in there so that there's no liability. And then you are in your notes, you have a little chart that speaks about on the left-hand side, the law of contract, and on the right-hand side, you would have written in your notes the relevance to banking. Yes, remember that? Yes. Okay. So you know you need to know that. Then we went on and we spoke about the banker-customer relationship. And we defined what is a bank. And we know that in common law, the definition of a bank was outlined in the case of UDT versus Kirkwood. And we know in the Banks and Trust Companies Regulations Act 2020, the definition of a bank is stated there. Then your note speaks about who is a customer, when a person becomes a customer, and it also gives the warning of when a person asks a banker for advice, even before the account is open, the bank can still be liable if negligent advice is given to that person. Then we spoke about the banker-customer relationship. Remember now, when you think about the banker-customer relationship, put in the back of your mind a contract. You see a piece of paper, you see A and B. Then they say what the contract is. A has agreed to purchase from B a car for $500. 3, the car is this, the car is this. Then they say, A, the owner will have the car fully serviced. A will also have the scratches fixed on the car. Like in your mind, you need to set out when you have a contract, there are obligations on both sides. When you go to the banker-customer relationship, I then want you to look at when in your mind, when a person comes in and they're signing that form to open an account. That form that they sign is a contract. That establishes that banker-customer relationship. Once they are to follow through the process to open an account, which means filling out the form, providing all the KYC documents, having them reviewed, having them approved, then they give the consideration, the amount needed to open the account, and it's signed, and then they get their ATM card, then that debtor-creditor relationship begins. And the foundation of that debtor-creditor relationship was founded in the case of Foley versus Hill. The third thing about that customer relationship is there are express and implied terms. And the implied express terms are the ones that you see written on that contract, that banker-customer contract, that form. But those implied terms, which over time have become express terms, those implied terms were outlined in the case of Joachimson versus Swiss Bank Corp. So from that case, it was determined that there are duties of a bank and there are duties of the customer. There are rights of a bank and there are rights of the customer. And you need to know those. And don't mix them up. So you know what the duties of a bank, just by the nature of their operation. They receive money and deposits for the customer. They collect and comply with checks written on the customer's account, and then there are restrictions on it. You have to have adequate funds or an authorized overdraft. The checks have to be properly drawn up and not forged, just stale dated. There mustn't be a countermand on your checks. The next duty of the bank is to repay the customer's entire money on demand. So if someone has in their account $300.50 and they write $350, that is what they want, minus whatever charges, if necessary. And it has to be done during banking hours. The bank has the duty to give reasonable notice before they close a customer's account. And remember, I said that reasonableness depends upon the type of business that the customer is carrying out. The fifth duty is the duty of confidentiality, Section 77 of the Banks and Trust Companies Regulations Act. And that section is based on the common law case of Turnier versus National Provincial and Union Bank of England. And in that case, it said there are 4 exceptions. 4 exceptions when a banker can disclose a person's personal information, which is Unit 5. Disclosure under compulsion of law, disclosure in the public interest, disclosure in the bank's interest, and disclosure with the customer's express or implied consent. The next duty, number 6, is they have a duty to provide a statement of account to the customer periodically and upon request. And this number 6 is what we're going to look at after the exam when we're going to read the 2 cases. I need you to read them before you come to class. The case on McCushla, Pinder versus Scotia, and then Scotia versus Pinder. And 7 is to exercise proper skill and care in carrying out the customer's instructions. So those are the duties of the bank. Then you need to know the duties of the customer. And of course, the first one is that they have to pay reasonable charges for services rendered. They have to issue checks only if they have sufficient funds on their account. Or again, if they have an agreed overdraft facility. And they have to exercise reasonable care when they're drawing checks to make sure there's no fraud. And the 4th one is they must advise the bank of any known forgeries. So duties of the bank, duties of the customer. Then the bank has rights. The bank has a right to charge a customer. Again, it's that keyword, reasonable commission for services and interest on overdrafts and loans. They could make a demand for any loan or overdraft. They can exercise a lien over any securities that were being deposited. But they cannot put a lien over items that are in a safety deposit box. They could be, they have a right to be reimbursed for any expenses or liabilities for acting or like following a client's instructions. Because whenever a bank carries out its client instructions, other than the client making a deposit, then the bank becomes an agent of the customer and a fee should be charged. The bank also have a right to return any unpaid checks where there are insufficient funds. And they also have the right of set off. And they have a right to combine accounts. A customer has a right to repayment of funds deposited on demand. They have a right to have the bank discharge its duties to the customer. So that is a right of the bank to discharge its duties. They have a right to have the funds deposited appropriately to the specified account to cover checks that the customer wants to pay. Then from that, we spoke about appropriation of payments, the rule in Clayton's case. This really refers to partnership accounts. Then we went on to the bank's right to combine accounts. The bank has a common law right to combine accounts, where the customer has 2 different accounts with the same bank, and they can do that without giving notice, even if they are at different branches. And if there are even more accounts, the bank has the discretion to combine any one that they choose. Then, like I said earlier, the bank cannot put a lien on items that are held in safe custody. That is a separate contract, and it is an arrangement called bailment. And we spoke about the different types of bailment, bailey for reward, and gratuitous bailey. And we also spoke about the bank having a duty of care when it collects items from customers that are to be placed in storage, and that the bank can be sued for conversion. That means that they gave the property to the wrong person, or the properties were damaged or they were stolen. All of those are actions in which the proper owner can bring an action against the bank, either for damages, for losses, or for theft. Then we mentioned night safes. And we said that when a night deposit is made, the monies are put in the chute, that is bailment. And only until the banking officers open that chute and takes that money out, then it becomes a part of the banker-customer relationship. Then we spoke about the termination of the banker-customer contract itself. And we said a banker-customer contract can happen in 3 ways. One is by the customer itself. And they can do that by just coming and asking for the balance on their account. Or the bank can do it by giving reasonable notice and closing a customer's account. And then, of course, the contract can terminate by death, by mental incapacity, bankruptcy, or insolvency. This sounds like a lot, eh?
It does, along with the cases we have to study. Yes, it does.
Oh. And then the last but not least area is the duty of confidentiality. And the confidentiality, we went through the 4 exceptions. And I gave you all some cases on it. Now, the duty of confidentiality will be a scenario question. I can't think of a multiple choice question because there are 4 exceptions. And anything I put there saying which one it is and which one it isn't, it'd be too obvious. So you'll have a question on confidentiality. So you should know what the 4 exceptions are. And remember what I said, you should be familiar with section 77. And you should also be familiar with the Data Protection Act because they go together. Does everybody feel comfortable now? So when I write this exam, I don't hear no screaming. It ain't that bad.
I don't think comfortable is I don't know the term I want to use, but I don't know. I guess I feel a little bit better.
I can scream regardless.
Oh my God. Okay, so for not Wednesday coming, that's your exam. For the class afterwards, when we're going to do 6, I want you all to read the case of Whitlock. I sent it already in one of those earlier emails.
Confidentiality is on the midterm as well, correct?
Yes, that's where we end.
Okay.
Yeah, confidentiality is there. Yeah, so for chapter 6, I want you all to read the case of Whitlock, which will be on the 8th of November. Yeah. And then after the midterm, so you all don't panic, I'll send you all the 1 question worth 20 points. That's a part of your final on checks. That sounds good?
Yes.
Okay. The question on checks, November 8th, I'm writing it down. And you all will also read the case of Whitlock. And if you have time, you can start reading the 2 Scotiabank cases. Because they are long. I think each one is like 30-something pages. So you need to read those.
Mr. Archer, in regards to these cases, what exactly is it that we have to learn? Is it like every detail of the case or just the general?
The general principle.
Okay.
Yeah. So like how thing I'm putting her answer, the one I read. Hold on. Some of them I didn't print. I can tell you right now how to do it. I want you to word it like how she did. Okay, so say how this one here, how Nadia, when she did her first one, she said, she's talking about the minor. And then Nadia says, in the case of Peters versus Flemings, it was found that a gold ring and watch chain were necessaries for the child of a member of parliament. Because of the nature of this contract with the minor, it was enforceable. You see how she tied it right in? And then like in another one, when she said, for question 2, she said, once a person becomes a customer of a bank, according to Joachimson versus Swiss Bank Corporation, it is the bank's duty to collect and comply with checks drawn on that person's account once the funds are available. So she put the name of the name of the case, and then out of the duties, she selected the one that was relevant to the question.
Okay.
So what I always tell students is when you get an exam, the first thing you do, even before you turn over the paper, you get a blank sheet of paper, you write down your cases. Joachimson versus Swiss. Duties of the bank.
How many structured questions will be in the test again?
I don't know. It's 50-50. I haven't written it yet.
Okay, and what about like the estimate time we had
3 hours.
Okay.
3 hours. So you get a blank sheet of paper, you write down your cases so you don't forget, and then flip it over, and then you do a cross, a big cross. The top left, you put the duties of a bank. On the right one, you put the rights. On the bottom, you put the duties of the customer, and on the right, you put the rights of the customer. So as you write your answers, you don't have to be guessing. You will not get confused. Because you could just turn that sheet of paper and everything you're looking for will be right there. You understand?
Is this still located on Shirley Street and Elizabeth Avenue?
Yes.
Okay.
You understand what I mean? Because I find students do that. When they start writing the exam question, they mix up the duties of the bank with the ones for the customer. They have the rights all mixed up. Then they start using the wrong cases. All you have to do is when you walk in the exam, we call it dumping. You just dump it. Put a big cross and fill in each block. And you go from there. All right? You feel better now?
Getting there.
Getting there. Well, now you have to study. Now you have to study. It's not that bad. It's only the midterm. This isn't the final yet. So don't die. And of course, remember I told you, you got to look at the law of contract and its relevance to banking. All right? Everybody's good. No more questions, right?
No, Mom.
Okay, all right. I'll find out from Ms. Dean when it's the last day. So I can make sure we cover everything that we need to cover. Okay. All right. So have a good evening. Start studying. If you have any questions, you can always shoot me an email.
Okay.
All right.
Okay.
Okay.
Okay,
right.
good night.
All right.
You know.
Good night.